Good morning, students, and welcome to the classes of costing and taxation. We were doing income from house property, and in the last class, we had covered topics of self occupied house property and we gave an introduction to deemed ownership. So, in deemed ownership, we had discussed that sometimes what happens, people transfer their house property to someone else in order to save tax. So, for that purpose, the Income Tax Act has come up with provisions that in some cases, what happens when the property is transferred, the transferor shall be considered as the deemed owner. Or there are some cases where there is a property and the person who receives the rent is not the owner, right? Suppose there is a property and the person is not the owner of it, but he has given the property for rent and he earns income from house property. So in that case, the person who is not the owner shall be considered as the owner for the purpose of income from house property, or for the purpose of this act only. Although the registered owner or legal owner is someone else, but for the purpose of this act, the person who receives the rent or the persons that we'll talk about will be considered as the owner. That is called deemed owner. So the first point is transfer of house property to spouse or minor child without adequate consideration. Sometimes what happens, a husband or a person transfer his house property to his wife or husband respectively. Suppose this is Mr. A and he has transferred his house property to his wife, correct? Now the cost of the price, the sale value of house property was around 50 lakhs. If Mr. A would sell it to someone else, Mr. A would get around 50 lakhs. But he sold the house property to his wife only for 5 lakhs. So that becomes inadequate consideration. That is the meaning of adequate consideration. What does consideration means? If I'm going to the market and I'm buying some product, the price that I am paying for the product is known as the consideration. Now what does inadequate consideration means? If the person is taking a very low price for the product, it means the consideration is inadequate, correct? Now here what happens, Mr. A has transferred his house property to his wife for inadequate consideration. Here the legal owner is the wife of Mr. A, right? In the eyes of law, she is the actual owner. However, the income from house property shall be paid, the tax on income from house property shall be paid by Mr. A. Why? Because he has transferred his house property to his spouse, and that too without any adequate consideration. Now, if Mr. A would transfer this house property to his brother or sister or friend, then it was not a problem. But the law states that if he transfers his house property to his spouse, to his wife, or to his minor child without adequate consideration, then Mr. A shall be considered as the deemed owner of the house property. Correct? Now I'm giving you a situation. Suppose Mr. A transfers his house property to his friend for 5 lakhs. Right? Mr. A, whose property is worth of rupees 50 lakhs, he transfers his house property to his friend only for 5 lakhs. Now, for the purpose of this act means income from house property. For the purpose of this act, who will be considered as the owner, Mr. A or the friend of Mr. A? It will be the friend of Mr. A. Why? Because although he has transferred it for inadequate consideration, but the friend of Mr. A is not his spouse, or he is not the minor child of Mr. A. The only situation where the transferor or Mr. A shall be considered as the owner, if and if only he transfers the house property to his spouse or minor child and the consideration is inadequate. Now suppose if Mr. A transfers the house property to his wife for 50 lakhs only, for 50 lakhs, not 5 lakhs, but for 50 lakhs. So in that case, this the wife of Mr. A shall be regarded as the owner of house property for all purposes. She will be the legal owner also, and she will be the owner of house property, means she will be the owner as per the income from house property also. Okay, so you can copy this explanation if you want. Second, same thing, deemed owner, what happens, Mr. A has transferred his house property to her or his minor child. Minor child means whose age is below 18 years. So what happens here, Mr. A has transferred his house property to his child who is minor for inadequate consideration. Then here Mr. A shall be considered as the deemed owner. The exception is that the transfer is made to a minor married child. Acha, if Mr. A transfers his house property to his son who is a major, right, who is a major, then the son shall be considered as the owner of house property. But the condition should be that he transfers his house property to his minor child, that too for inadequate consideration. The only exception is that if the transfer is made to married child, minor married child, then what happens? Then the minor child shall be considered as the owner of house property. And in this also there is an exception. When a person transfers his property to his spouse or her spouse, there is an exception that if the transfer is made to live separately, means if they are divorced, if they are not living together anymore, then the person to whom the house property is transferred will be considered as the owner. Okay. Second, property held by a cooperative society or other association to whom building or part thereof is allotted. Okay, what happens now? This is a cooperative society. What happens? A cooperative society is a group of people, it is a group of many members who come together, and they help each other for various purposes. For example, you may have heard the communities like Marwari or Sindhis. They all of them have a cooperative society and they help each other. Each member of the cooperative society is helped by the other members. Now what happens in this cooperative society? They make an apartment, a big apartment, and each apartment is given, or an apartment is given to a member of a society, a member of the society. Now suppose this is Mr. X, and Mr. X is given the house property from the cooperative society, right? So what happens, the owner of the cooperative society is the owner of the house that Mr. X is given is the cooperative society. What did I say? The owner of the house that is transferred to Mr. X is cooperative society. However, Mr. X shall be considered as the deemed owner. Means if he gives the house on rent, then the tax shall also be paid by Mr. X and not by the cooperative society. Here, although the legal owner is cooperative society, but taxes shall be paid by Mr. X. Third, what happens? The holder of an impartible estate. Nothing to understand really very much. It means that the property which is not legally divisible. For example, if there is a father who has a house and he has three sons. Now before death, the father did not confirm that who will be the owner of the house property. So the house property becomes an impartible estate. It is not sure that who will be the owner of the house property. Right? It is means all the three sons, they don't know that who is the real owner because the father didn't confirm before his death. So what happens? The person who takes care of the property, right? The person who is the caretaker of the property, he becomes the owner of the house property, right? Bus. Next, very easy point. What happens if the lease is for 12 or more years? Suppose I am the owner of a house property, and I have given you a house for rent, right? You came to me and you said, I want a house for rent for many years. I told you, take this house for rent for 15 years, right? If the if the lease is for more than 12 years or 12 years, then the person who is the lessee, means you, means I am the owner, I am the lessor, means I have given the property on lease and you have taken it on rent. So you shall become the deemed owner of the house property. Means if you are earning income from house property, I will not pay the tax, you will pay the tax. All right, what did I say? If the house property has been given for rent for 12 years or more, then the person to whom the house property was given on rent shall be considered as the owner of the house property. Clear? Last is disputed ownership, where what happens in many places, in many cases, what happens, there are two owners and the ownership is in dispute, and their case is still in court, and the court has not yet decided that who is the real owner of the house property. So in this case, what happens when the house property is given on rent and the income tax authority comes to receive tax, then the both the disputed owners, dispute means quarrel, ladai jhagda. So what happens, the tax officer comes and he asks for tax, and then the disputed owners, they say that I am not the owner of the house property, then why will I pay the tax? The tax officer says, okay, but who receives the rent? If Mr. A receives the rent, then okay, you will pay the tax. If Mr. B is the person who receives the rent from the tenant, then Mr. B will pay the tax. So number 4 and 5 are quite easy. You'll have to work on number 1, especially transfer to spouse or minor child. We'll solve some examples. Here, who is regarded as the owner of the house property? Here what happens, Mr. X has given the property as a gift. Gift means inadequate consideration. Understand? They did not mention inadequate consideration, but they mentioned gift. Now, for gift, you won't take money from someone. So it is transferred for inadequate consideration and transferred to his wife, Mrs. X. I haven't written over here, but Mrs. X is obviously the wife of Mr. X will be Mrs. X, not Mrs. A. Okay. So Mr. X transfers the house property to his wife for inadequate consideration. Who will be regarded as the owner of house property? Mr. X. However, the legal owner is Mrs. X. Next, Mr. X transfers his house property to Mrs. X, and he has transferred for divorce. Now, this is an exception, right? In the above explanation, I told you that if both the persons they are divorced, then this person to whom the property is transferred shall be considered as the owner of the house property. Third, Mr. X gifts his property to minor child Y. Here who will be considered as the deemed owner? Deemed owner shall be Mr. X. Okay, minor child plus inadequate consideration. Next, Mr. X gifts his property to married minor daughter Z. Right? So he has given his property for inadequate consideration, but given to whom? To married minor daughter. So this is an exception. If the minor child is married, then he or she will be considered as the deemed owner, or he will be considered as the owner of the house property. So here Mr. X is not the deemed owner. Next, Mr. X gifts his property to married minor son A. Same thing, the child should not be married. If he is married, then he will be considered as the owner of the house property. Next, Mr. X gifts his property for inadequate consideration to whom? To major son or daughter. Same thing. Major son or major daughter. So here the son or daughter shall be regarded as the owner of the house property. Last, gifts his property to parents or brother, sister and friend. All these people shall be regarded as the owner of the house property. So I'm not giving any homework in for this class. However, I have given homework for accounts. So please make sure you do your homework for accounts and send it to me by Monday or Tuesday max to max, please. And go through this topic. And if you have any problem, please don't hesitate to ask me. If you ask me as early as possible, I'll be able to explain you as better as possible. Thank you so much and have a good day.